A crucial order today was delivered by the Allahabad High Court. The plaint that was filed by the Hindu side, which is seeking the worship of Ma Shringar Gauri at the Gyanvapi complex, that plaint is good in law. You'd remember there was an order that had earlier come in from the District Court in Varanasi, where it was argued that the Hindu side plea is maintainable under Order 7, Rule 11. That particular plea is maintainable. That was the order of the lower court. This particular order was challenged at the Allahabad High Court by the Muslim side. Now, the High Court has ruled that the Hindu side plea is maintainable. What does it mean? Well, for starters, it immediately does not mean that the worship of Ma Shringar Gauri at the Gyanvapi complex will be possible. All it means is that the trial at the lower court can start. Yes, there's a remedy. They can go to the Supreme Court. The Muslim side can go to the Supreme Court. But right now, there is no stay. That means the lower court is free to begin the trial. This particular order that has come in from the High Court has bigger ramifications. Though in a civil dispute, it's an ordinary order which has come in to the relief of one party and not a significant verdict on the merits of the case, it means that multiple petitions that have been filed so far in the Mandir Masjid dispute, in the Gyanvapi case, for the Hindu sides, there is a relief. This particular plaint, which was about seeking the worship of Ma Shringar Gauri, forms in many ways the core of a lot of litigation which is going on. This particular suit is also important from the point of view that when the survey was done of the mosque, there was a shivling-like structure that was found in. And for that particular structure, right now there are orders from the Supreme Court where that entire area has been sealed. There's also the order of the carbon dating which has been put in abeyance by the Supreme Court. The other plea has been that the entire area of the Gyanvapi mosque should be inspected by the Archaeological Survey of India. These multiple plaints, these multiple suits in this big battle of the Gyanvapi Masjid, about which the Hindu side argues is a case of encroachment, was very much dependent on this High Court order. So what does this High Court order really mean? A, the plea of the Hindu side is maintainable. B, that the trial court can go ahead and start proceedings in this matter. It's going to be a civil suit and their proceedings which will begin at the lower court. C, the other plaints, say the Archaeological Survey of India should inspect the entire mosque premises, or there should be a carbon dating of the Gyanvapi, inside the Gyanvapi area, the shivling-like structure that has been found. All those multiple plaints and suits can go ahead. This particular relief is very important because the Places of Worship Act was also cited by the Muslim side to say, per se, this suit is not maintainable. With the lower court, with the higher court agreeing with the Hindu side, this is a huge relief coming in for them. Yes, these orders will be challenged at the Supreme Court of India by the Muslim side. The Hindu side has said they're going to file a caveat at the Supreme Court in this particular matter. But with the two court orders firmly planted in the favor of the Hindu side, it looks like that the initial battle has been won. Let's come to the merits of the case. The merit of the case, at least in this particular suit, is a petition by about 5 Hindu women who seek the worship of Ma Shringar Gauri, and that particular structure, those particular deities are inside the Gyanvapi mosque complex. For that particular relief to actually be given to the Hindu side, the hearing has to start on merits. With this High Court order, now the hearing can begin on the merits of the case. And indeed, this is a small but a crucial impediment that has been sorted for the Hindu side, and all eyes on the Supreme Court as and when the appeal from the Muslim side goes to the apex court of the country.